And welcome to the History of Black Judges and Lawyers in California. My name is Nichelle Holmes, and I am the president of the Charles Houston Bar Association. Tonight promises to be an amazing program. We couldn't think of a better way to close out Black History Month than to learn about the men and women whose shoulders we stand on. Although let me just say for the record that we here at Charles Houston and our co-sponsors celebrate Black history all year long. Our panelists here are our history, tomorrow's history, our legacies. Our co-sponsors for tonight's program are Duane Morris LLP, the California Lawyers Association Racial Justice Committee, the litigation section of the California Lawyers Association, the Charles Houston Bar Association, Region 9 of the National Bar Association, and the California Association of Black Lawyers. I would like to first thank and introduce our moderator, Terrence Evans. Terrence is a partner in San Francisco and Los Angeles, and the Los Angeles office of Duane Morris LLP. He serves as the co-leader of the firm's banking and finance services practice. Terrence is also the co-chair of Duane Morris's San Francisco Diversity and Inclusion Committee. Terrence, as you know, is my vice president of the Charles Houston Bar Association. He's the chair of the litigation section of the California Lawyers Association. He's also co-chair of the American Bar Association ICLC Diversity and Inclusion Committee. He's co-founder and co-chair of the CLA Racial Justice Committee. And he's also deputy director of Region 9 of the National Bar Association. We would be here all night if I went through all of his accolades and accomplishments, but I cannot. I would be remiss if I missed out that he travels back and forth. He takes care of his entire family in Los Angeles, including his parents, and he cooks these elaborate meals for them. And we're like jealous because he teases us through Facebook with pictures of his great meals. And he manages to lift 500 plus pounds on a daily basis. So he is amazing. He's going to be our moderator tonight. And we just like to say thank you to him. And without further ado, I'm going to turn it over to Terrence to introduce our great panelists.
Nichelle, thank you so much for that amazing introduction. And also thank you for your friendship and your leadership of the Charles Houston Bar Association. I want to thank everybody for being here tonight and sharing your Friday evening with us in celebrating Black history and this important topic of the history of Black lawyers and judges in California. As we put this program together, we realized that there was so much information that it's impossible to cover all of it tonight, but we certainly want to give you a taste of some of the key figures in Black history in California who have made an impact on our great country. We have an incredible panel tonight, and I'm so grateful that they accepted our invitation. I'm going to keep the introductions brief, but these are all among the heaviest hitters, the most respected, the highest regarded leaders in the African-American community and the legal community. Starting out, we have Assistant Presiding Judge of the Alameda Superior Court, Judge Charles Smiley. Judge Smiley has spent more than 2 decades of his life researching and archiving African-American legal history. And he will be the first speaker that you hear from after me, going through the incredible research and what he has discovered and learned about our past and our future. We also have with us the very distinguished and honorable Judge Brenda Harbin-Forte from the Alameda Superior Court. For the past 35 years, Judge Harbin-Forte has researched both African-American and women's history in California and the impact that women lawyers and African-American lawyers have had and also on the bench. She's been instrumental in working with both Republican and Democratic administrations to diversify the bench. And she has literally, through her incredible work, changed the complexion and diversity of our bench here in California. She was also instrumental in making sure that the state of California tracks the diversity so we can understand where we are and where we're going. We also have with us the incredible Bob Harris. Bob Harris has been the past president of the National Bar Association, which is the largest Black bar association in the world, past president of the Charles Houston Bar Association, which is the oldest Black bar association in California, and he was the co-founder and also past president of the California Association of Black Lawyers. Bob has been instrumental in a number of civil rights cases and matters that go to our ability to advocate for people of all backgrounds in California. He's been instrumental in the formation of the organizations that we hold near and dear to our heart, and he has been a game changer for several decades, and we so appreciate him being here. And last but certainly not least, we're so happy to have with us the Honorable Judge Demetrius Shelton. Demetrius has been involved in leading numerous organizations, including past president of the National Bar Association, past president of the Charles Houston Bar Association, past president of the California Association of Black Lawyers. He was also one of the first African Americans to ever serve in leadership of the State Bar of California. He was the vice president, and he was very instrumental in a lot of the diversity and inclusion work that paved the way for all of us today. Without further ado, I want to introduce to you our next speaker, which will be the Honorable Judge Charles Smiley. He will be speaking for about an hour about his incredible research, and then we will bring the panel in to have a further discussion about these important Black history issues. Judge Smiley.
All right, thank you. So to begin, in 2003, Charles Houston Bar Association President Vernon Goins asked me to be the communications chair. And I thought, sure, no problem. Happy to support you. I thought my job would be easy because for whatever newsletters or other publications I needed to produce, I knew I could just go to, at the time, I think Yahoo was probably the leading search engine, and find everything I wanted to know about some of the great Black jurists I had seen and admired from afar. Turns out that wasn't the case. And that kind of began my journey in trying to capture a history that just felt inaccessible. So tonight, I want to use some slides and articles and information I've picked up over the years to introduce you to some laws and to some people you probably don't know yet, unless you've seen me give this presentation before. The focus here is on Northern California, and our host, the Charles Houston Bar Association, is a love of mine. So a lot of my research focuses on this particular corner of the world. But the story applies to everyone in California, because when California began, and I'll talk about this briefly, the Black Population Center was in Northern California. It's the little people who make history. I'm not going to be talking about the big names that we know, because my research has shown that the story of Black advocacy in the state of California relied on the efforts and sacrifices of people who history might forget if we don't keep this alive. And as you watch these slides, I want to ask all of you to think about joining an effort of scholarship, of preserving this history and getting it in writing, because there are stories out there to tell, and people who we just don't have time to address today, but who deserve their own 1-hour presentation or book or article. In fact, Terrence and I were talking about collecting essays on some of the history investigation people can put together, and maybe asking Charles Houston to put out a publication. To begin today, I have to acknowledge the passing of 2 judges last year. On the left, you're looking at Judge Sharon Chapman from Santa Clara County Superior Court. Her great love was basketball, and she was in fact the women's basketball coach for the San Jose Spartans. But she was an amazing judge. And among her attributes, she was known after she was appointed by Governor Gray Davis in 2000 to have very impactful conversations with people. She would turn a progress report into a transformative experience for folks. She took her work very seriously and started several nonprofits and other organizations because she saw that the families who were affected by the court's work also deserve support. And she was the one who stepped up to provide it. On the right is Judge James Long. People affectionately refer to him as Jimmy. long, and he was appointed to the Sacramento bench. In fact, he's the second African-American appointed to that bench. He's a graduate of Howard Law School in 1967. Jerry Brown appointed him back in 1982. He'd served in the Army, and while he was a lawyer, I mean, this is one of the heavy hitters from Sacramento. He represented the Black Panthers and the NAACP. He mentored many people. And as a judge, he tried some of their heaviest cases and has won all sorts of awards. So tonight, we dedicate much of our conversation to two titans in the legal community whose work we are grateful for and on whose shoulders we stand. To begin my talk today, though, I want to talk about the peculiar relationship between African Americans and the law. And it's difficult for me to put it into words. So I'm going to turn to the poet. And sometimes it's the poet who says it best, wrapping difficult and complex and even painful ideas into a new perspective. So as you read this, understand that Tamis, who we call Lady Justice on the right, is who we're talking about in this poem. And the poem is asking us to think about justice. Is Lady Justice blindfolded for a noble purpose? Or is she really ill and blind to justice? The interesting thing about this poem is that it's just as profound today as it was when Langston wrote it in 1923. Or maybe the best way to start this talk off is to talk about another lawyer, Patrick Henry. You'll know his name. He's the guy who, during the 1775 speech to one of the Virginia conventions, the second one, said, "I know not what course others will take, but as for me, give me liberty or give me death." He also said the quote you're looking at here. He disagreed with chattel bondage, with slavery in concept, but he could not bring himself to follow what he knew to be correct, in part because he had a large estate dependent upon 67 human beings who were in chattel bondage. I will tell you, for those of you listening, that there's a force of history identified by Justice Leon Higginbotham in his open letter to Clarence Thomas in 1991 that I think applies to all of us. Without going into detail about the reason for the letter, I want to focus on just a few parts of what he says. Please read it with me. You know, the president has suddenly vested in you the option to preserve or dilute the gains this country has made in the struggle for equality. This is a grave responsibility indeed. In order to discharge it, you will need to recognize what James Baldwin called the force of history within you. He goes on to say that you will need to recognize that both your public life and your private life reflect this country's history. And while much has been said about about your admirable determination to overcome terrible obstacles, it is also important to remember how you arrived where you are now, because you did not get there by yourself. And it goes on, if you look towards the middle, it says, I know you may not want to be burdened by the memory of their sacrifices, but I also know that you have no right to forget that history. I always think about this quote because it gives me, as a Black person who's chosen a career in the law, a mission and a purpose. And it gives me an opportunity to reflect time and time again on the power our profession has over the lives of people and over the trajectory that our people and the country take. When I'm together in person with folks giving this presentation, I look out and see who I'm talking to, and I get to understand who my audience is. If there are a lot of people of color out there, I always begin with this slide, because when California started, nobody envisioned a room full of Black folks or people of color. Quite to the contrary. When California began in 1850, the decision was made that California would enter the Union as a free state, meaning no slavery would be allowed. This wasn't for some moral purpose. It was a part of this much larger bargain. And in fact, for the people who wanted California to be admitted as a state, it was very much a bargaining chip because they wanted ratification of their statehood. The best way to do that was to say, we're going to come in as a free state. So when that happened, this compromise did several things. One, it caused a decision that new territories joining the United States or who had yet to become states, they would decide for themselves whether or not they could practice slavery. And also, as a part of the bargain, a more stringent fugitive slave law was enacted. Now, the fact that California entered the Union as a so-called free state didn't do anything to change the way people felt about folks. In fact, the first governor of the state of California delivered a speech on December 21st, 1849. This was his State of the State address, where he said there's one of two consistent courses to take in reference to this class of population. He was talking about Black folks. Either to admit them to the full and free enjoyment of all the privileges guaranteed by the Constitution to others, or exclude them from the state. Now, he's talking about excluding Black folks, whether you are free or slave. He says, if we permit them to settle in our state under existing circumstances, we consign them by our own institutions and the usages of our own society to a subordinate and degraded position, which is in itself but a species of slavery. They would be placed in a situation where they would have no efficient motives for moral or intellectual improvement, but must remain in our midst, sensible of their degradation, unhappy themselves, enemies to the institutions and the society whose usages have placed them there, and forever fit teachers in all the schools of ignorance, vice, and idleness. This is the top of the California government saying this. And he concludes later in the speech to say, had they been born here, talking again about Black folks, I should not recommend any measures to expel them. He's saying that for the people who were born in California at the time we became a state or become a state, they can stay. But they are not now here, and the object is to keep them out. There were several unsuccessful campaigns to keep all Black folks out of the state of California. Now, that didn't stop the first legislature in California from enacting a first set of laws that were purposefully inhospitable to the African American. Black folks could not vote, hold office, serve on a jury. They could not use public transportation. Interracial marriage was not permitted. There was also a fugitive slave law that was intended to make sure that when California became a state, a free state, those Black people who were in the state and who were slaves, they needed a mechanism to make sure these people wouldn't run away and then be able to be protected from returning to chattel bondage by staying in the new state. And so the fugitive slave law is what you're looking at here from 1854. It describes what it is the law seeks to do. Now, of all the indignities I just showed you, the law that troubled the early pioneer Black populations of California the most is the one you're looking at here. Now, this is the law that applies to criminal cases, and there's an analog in section 394 of the Act concerning civil cases from the same time period. They both say essentially the same thing. But if you look to the second paragraph in section 14, it makes Black people, mulatto people, and Indians incompetent to give testimony in any trial or case in which a white person is a party. And look at the interesting value judgment that's a part of the second sentence. Every person who shall have 1/8 part or more Negro blood shall be deemed a mulatto. And every person who shall have 1/2 of Indian blood shall be deemed an Indian. Interesting how they use the blood to indicate who can and cannot testify. And the value judgment is to place a heavier and harder burden on the Black man and woman. Now, this shows up in early cases in horrible ways. You're looking at a photograph of a building that had a basement. And in the basement were a couple of shops. One of the shops was a barber shop. The other one was a millinery, which is a women's hat shop. These two shops were owned by a brother and sister. They were both African American. One day, white man walks into the hat shop, goes to the till, steals money, and leaves. The woman, the proprietor of the hat shop, runs out after him, screaming in the open street, "Stop, thief!" Now he gets away. The next day, the same white man returns to the hat shop in the basement of this building. The basement, by the way, is located in San Francisco at the corner of Bush and Sansom. There's a Target there now for you San Franciscans. White man returns to the hat shop, and the woman is not there, but her brother, who owns the barber shop, is there, and he comes over to see what this person needs. And the white man begins to say, "I need an apology. I need an apology from your sister, because yesterday she ran out of the store after me into the street, accusing me of being a thief to the public." Well, words were exchanged after that, and George Gordon, the Black barber, was shot dead. Now well, that's sad all by itself, but a case followed, a case where the issue became whether or not the one witness to this murder could give testimony upon which a conviction could be sustained. You see, there was a person in the barber shop named Robert Coles. Mr. Coles was a light-skinned person, and he gave testimony having seen the murder. And the question, or the objection in court was, this person can't give testimony because the defendant in this case is a white man, and we believe Robert Coles might be Black or mulatto. The judge in that case called two experts. These are folks who went around the country claiming that they had a special ability, a scientific ability, to identify African Americans from an analysis of their hair and nails alone. The judge called them in, and they did their tests, and they concluded that Robert Coles was in fact a Negro, making his testimony inadmissible. The man who murdered George Gordon walked free. Something similar happened with Mifflin Gibbs. Now, Mifflin Gibbs was an entrepreneur. He owned a boot shop in San Francisco. And remember, this is the early days. The 1849 Sierra foothills were filled with people from all over the world seeking their fortune. It was a brilliant idea to have a boot shop to supply all these miners with their clothing. And he did well for himself. And he had a partner who was also African American. One day, a man walks in, sees a pair of boots he likes, and says, "I'd like to purchase those. Please hold them for me. I'll be back tomorrow." He leaves. Later in the day, another white man walks in and sees the same boots and says, "I'd like to purchase those boots right now." Mr. Gibbs and his partner politely explain, "Can't do that. We're holding them for someone else." "Well, who are you holding them for?" They explain who the person is. And the second man says, "I know who that is. Listen, it won't be any problem if you let me purchase them today." And so the sale is completed. Now, the next day, the other man comes back to purchase the boots. He has to be set aside. And in anger, he beats Mifflin Gibbs's partner within an inch of his life. Now, this didn't result in a court case. It resulted in Mifflin Gibbs, a leader in the community, rallying the Black folks from the Bay Area in what was to become a series of colored conventions. So even though at that time we weren't allowed to participate in the justice system in California, there was Black advocacy. There's always been Black advocacy throughout our history in the United States. But here, the example I'm going to give you with Mifflin Gibbs is this. There were 4 colored conventions where Black men, mostly at the time, gathered. These were community leaders from all over the Bay Area. They developed consensus and wrote petitions that they would take to the government in Sacramento to plead their cause. And chief among their grievances was this ban on Black testimony. In 1854, they went up there and asked and were denied. They did the same thing in 1856 and 1857. And it wasn't a result of their efforts alone, but the combined effort of a population that began to see that this rule isn't really working justice for anybody. Because remember, if the only person who sees the crime committed can't give testimony, even the white victim lost out. It wasn't until after the 13th Amendment was about to be ratified that the law actually changed in a way I'm going to explain to you in a moment. A brief word about Mifflin Gibbs, though. Mifflin Gibbs, as a result of this incident, it did bring the African-American community together at the time, but Mifflin Gibbs himself left the country. He went off to Canada, and after spending some time there, he returned to the United States, but to Little Rock, Arkansas, where in 1873, he became a municipal court judge. One of the first, maybe the first, west of the Mississippi. Now, this law on the testimony ban shows up in a case that I'll urge you to read. Check out the citation and read this case whenever you get a moment. It doesn't involve Black people per se, but involves the law I just showed you a moment ago. So remember, the law excludes the testimony of Blacks, mulattoes, and Indians. People versus Hall. This is a murder case from the gold mines out in the hills. In those days, the miners would congregate in camps, and the camps usually were people separated based upon your ethnicity. So there were camps where white miners would be, and Chinese and Blacks and other ethnicities. Well, one day, George Hall, his brother and a third man, went over to the Chinese camp to commit a robbery. And during the robbery, one of the Chinese men was shot in the back and he died. The witnesses who were there were also Chinese. Case goes to trial. Chinese witnesses testify. Upon their testimony, a conviction is obtained for murder. It goes up to the Court of Appeal. And in the appellate courts, the issue isn't whether the evidence of murder was, whether the murder occurred. It wasn't even whether George Hall committed the murder. The question was whether or not a Chinese witness could give testimony in a criminal case against a white defendant. But the law said that only Blacks, mulattoes, and Indians were prohibited from giving testimony. So the issue was, what do we do with Chinese people? People versus Hall concluded that Chinese people are Black people as far as this competency rule is concerned. But read the opinion itself. The language you're looking at on this slide is but a taste of an express desire that certain groups, Blacks, mulattoes, Indians, and now Chinese, be excluded from access to all the levers of power in California society. People versus Ilea is another case. So when you have cases where, or rules that rely on people's ethnicity, all questions like the one I'm about to explain come up. The case of is Elia, is how you pronounce it actually, involved another murder, but this time the witness who saw the murder just had darker skin. Couldn't say this person was black or even mulatto, had a different look. And it turns out this witness was from the country of Turkey. And so the question was, what do we do now with this person? And so this weird legal standard is created, one that relies on clear and indubitable evidence. And it also goes on to talk about the indicium of color not being an infallible test. Now, if a Negro should offer to be sworn, he could be rejected upon sole evidence of his color. But in other cases, it would have to be proved by clear and indubitable evidence. Interesting, this history of treatment of African Americans. Now, as an example of how the lengths to which the law will go to narrowly construct statutes to arrive at a particular endpoint, I want to share with you the fact that the law regarding Black testimony eventually did go away around 1863. This is around the same time that the 13th Amendment is being ratified. So the law changed to provide that no Indian or person having 1/2 or more Indian blood, or Mongolian or Chinese, shall be permitted to give evidence in favor of or against any white man. Now, here, the case of People versus Washington, the defendant was a Black man. And the defendant said, wait a second, my conviction can't rely on the testimony of a witness who is Indian or Chinese or Mongolian, which in his case, one of those groups was a witness to his deeds. And the People versus Washington says Blacks receive the same benefits as whites because of the 13th Amendment. But they narrowly construed this change in the Constitution to only elevate Blacks to the same status as whites. And not wholly, because the dissent in People versus Washington argued that Congress could never have intended to put Blacks on the same footing as whites. To do so would mean, as the dissent illustrates, that Black men can also marry white women, which was already prohibited by another law and which no one intended. So Black folks were shut out of political and legal systems and indeed justice in early California. Now, many years later, Charles Hamilton Houston, pictured on the left, was trying to figure out, what do we do about the situation? How do we maximize our participation? And he sent out letters in 1928 all across the country to different jurisdictions to find out, where are our Black lawyers and what are they doing? And the responses he got are there on the right. Not good. The story in California, well, I'm sorry, this is a slide that talks about jury service on the top. There's a famous case, Norris versus Alabama, which in which the jury commissioner didn't call any Black jurors because given his testimony, he said he never knew a Negro in that county who possessed the intelligence, integrity, character, or judgment to qualify as a competent juror. That's in 1935. 4 years later, in Merced County, California, a case went up on appeal because there was evidence that no Black person had ever sat on a jury in that county as well. But that had been simply a custom to exclude all from jury service. In my experience as a judge, I'm always concerned that custom will trump the law. Whenever you hear someone say that's not how it's done, be concerned. So here's the law that gave people authority to become lawyers in California. Prior to 1878, only white male citizens who possessed good moral character and the necessary qualifications could become lawyers. Now, this didn't change until 1878 when, as the first two words in this updated statute reveal, any citizen of the United States residing within the state could become an attorney with certain other qualifications. But any citizen is the key here. This was a huge change, and we're thankful in part to this woman, a Hastings graduate. She had to sue to get into Hastings because they wouldn't take women. And after she got her JD, back then it was a different law degree, but after she received her legal training and wanted to become a lawyer, they told you can't become a lawyer either because you're a woman. And she, along with her allies in government, were successful in changing the law I just shared with you. But even after we were permitted to practice law, we were not well received. And indeed, in the book Emancipation, and in another book from California by Delilah Beasley, she talks about the prejudice being so great that it was many years after the law allowed Blacks to become attorneys that we began to see Black lawyers show up on the scene. Now take a look at the image on the left here and this article on the right. Algonquin J. Calhoun is the lawyer character in the Amos and Andy show, which used to be a radio show performed by white actors, and later it moved to TV with Black actors. So this is a later image of the Amos and Andy lawyer character, Algonquin J. Calhoun, and he is a buffoon. Now, I'm not saying that everyone didn't laugh at this as comedy, so there's a certain license and it might have some application to the times. But to the Black lawyer looking at it today, and you can find a couple clips of Algonquin J. Calhoun on YouTube, it's really offensive. He doesn't like his clients. He's trying to swindle everyone around him, including his clients. He is not smart. He is a mockery of the profession and the Black person's involvement in the law. Take a look. The article on the right gives you some idea in 1910 of the novelty of a person being articulate in court. This article talks about a pro se person talking so well that the judge decides, well, maybe we do need to listen to what's being said and put this matter over and give this some thought. It ends up being a newsworthy event, this Charles Washington successfully handling his own case in court. If you scan old publications, like I do sometimes, you'll find little paragraphs and columns that are just meant to give a smile or a laugh to the reader. And here's an example of one using a supposed Black dialect to mock a Black witness on the stand. These are ways that Black folks are viewed in the court. It's as if Black folks are not supposed to belong in that setting, to participate in the temples of justice. Here's an article where the woman refused to answer questions asked by a darky, and the judge had to plead with her. She still refused to answer. The rest of the article couldn't fit, but the judge at least had the good sense to find the witness. The news isn't all bad. The blurry article on the left is one from 1855. The federal court would allow Black testimony. They didn't have the same testimony ban applicable to Blacks, mulattoes, and Indians. And there's an interesting article from 1897 on the right-hand side, where a Black man walked into court and for his trial, he wanted his own peers. and they hadn't had Black folks participate on juries. So they went out and they, as the article says, ransacked the town for colored jurors who did come in, serve, and the defendant was promptly acquitted. The document here, this slide, is just meant to demonstrate, to give you another view of how the law has treated African Americans over time. Here I'm stepping outside of California, but this is important enough to bring up because I just want it on your minds, those of you who are part of this experience. The Civil Rights Act of 1875 sought to do the exact same thing as the Civil Rights Act of 1964. It meant to get rid of discrimination in public accommodations. But the Civil Rights Act of 1875 was found to be unconstitutional by the United States Supreme Court. You might recall in law school reading the civil rights cases. The civil rights cases was a collection of cases from around the country, including one from San Francisco, a streetcar case, and other cases where people were denied certain privileges and accommodations. And the court concluded that government was not in a position to do anything about private discrimination. The Civil Rights Act of 1964, in very similar language that I'm showing you here, found that the law was constitutional, not using a due process analysis, which is what was used to defeat the Civil Rights Act of 1875, but now looking to the Commerce Clause to find that it was valid. I want you to know that there's a book out there called The Petitioners, written by Lauren Miller, who's the brilliant attorney and judge in the background of this text. He's from Los Angeles. The book that he wrote, The Petitioners, is a great primer on all things civil rights because he had an upfront view to all of this. And in fact, he argued in the Supreme Court in Shelley versus Kramer, working with Thurgood Marshall to defeat racially restrictive covenants. His theory in the book, The Petitioners, is that, and he uses these civil rights acts as an example, is that the United States Supreme Court has, through its inaction and through delays, taken the Black person as a ward throughout this history. The comedian Dick Gregory says it differently. He says, we're the only people who had to go to the US Supreme Court just to get a cup of coffee. So putting some of this together in a timeline, 1850 is statehood. We have a convention movement, the colored convention movement from 1855 to 1865, where people are petitioning their rights, saying this is unjust, we want these laws changed. Now, out of that came precursors to the NAACP, the Franchise League, the Negro Welfare League, the Negro Equity League, and the Equal Rights League. These are different organizations that are now popping up, and we're seeing an organized movement because there's strength in a uniform voice against injustices. We have 1878, when Blacks can now participate as lawyers, but even then, we're not fully embraced. So in this timeline, I'm including a few additional features. The National Bar Association started in 1925. 11 men and one woman, or 10 men and one woman, I forget. My other panelists will know this for sure. But they started the National Bar Association. Why? Because other bar associations would not admit them regularly. In fact, skip ahead to that big circle for 1943. That's the year the American Bar Association finally accepted Black members. Now in 1927, this California State Bar decided to create one common program for all. Before that, if you belonged to a bar association, it was a private bar association in the jurisdiction in which you practiced. And they could do whatever they wanted. In 1927, they decided to create a state bar under the auspices of the California Supreme Court, and Black lawyers were concerned. They were concerned that this new state bar would be created and exclude them. And so Hugh Macbeth, another Los Angeles lawyer, and a group from the Blackstone Club down there of Black and Jewish lawyers, they got together and went to Sacramento to make sure that the creation of this new state bar system would not exclude them. In 1955, we know that 32 Black lawyers got together and started meeting as a group they called the Charles Houston Law Club. And in 1976, the Charles Houston Bar Association was formed. And a year later, the California Association of Black Lawyers formed. Just giving you a sense of the timeline, how short a time these things are. And over history, you can see that there's still a need for the law club in 1955. That's what pulls them together. There's still a need for Charles Houston and Cable. That's why these are institutions that have survived the test of time and are as relevant today as they've ever been, in my opinion. Clint White is one of the best trial lawyers in the Bay Area. When he was alive, he was also a Supreme Court justice. Our own Brenda Harbin Forte produced a great video about this man's life. And here's an excerpt from it where he talks about the formation of the Charles Houston Law Club. I hope you can hear it. You might need to turn up your volume a little bit.
We organized a club when we took the Charles Houston. We took that name because all of us were very conscious of the fact that we were social engineers. You're talking about a city of Oakland with more than 12 to 15 active lawyers. And I was the youngest of the bunch. You had Tom Berkeley, John Henderson, George Vons, Lionel Wilson, Cecil Fool. But if I kept counting, it'd be about 15. So we formed for one reason, simply to be able to impress the Black community as well as the white, that we weren't invisible men. You know, Charlie Wilson walked into a court in San Francisco, old Judge Fitzpatrick, but the fact still remains that he looked over, this is probate, he looks over and he says, who do we have here? You'd never seen Charlie Wilson before. Charlie was a Virginian, a very good, still living out in El Cerrito, retired. He looked down and he says, what do we have? A nigger in the woodpile? Well, no apology was needed. We went after him. And anybody that wanted to agree with him or belittle or downsize anything he said, and you never made that mistake again. We organized.
So I want to talk, or actually just show you an image of Benjamin Travis, the judge from my court, Alameda County Superior Court, who is worth special mention. I suspect he'll be discussed in the panel that follows, but I want you to see his face, because here's a man who has the foresight, the organizational skills, and who knows how to motivate people, along with Robert Harris, to be more. And that's exactly what he did in his work with the Charles Houston Law Club and his work with the California Association of Black Lawyers. He was about organizing people in a way that this history I'm trying to show you has required of the Black community to do for self, to be organized, and to speak with one voice for the change you want to see in your lives, in your community, the state, and indeed the world. He is a social engineer. I'm going to move quickly now because I'm going to show you some people you probably don't know already. Some of my research has brought me in touch with names. I didn't know these people were out there, and it's significant to know who they are because they're pioneers. They blazed a trail, and we're all benefiting from the work that they did. And it's a shame that we're losing some of them to history. The first Black lawyer in California is RCO Benjamin, Robert Charles O'Hara Benjamin. Now the date that you're looking at is the date he was murdered. He was murdered in Kentucky doing what we would consider today election protection. But he shows up around 1887 in California. I've read about him being in San Diego, in Los Angeles, and briefly in San Francisco, where he was trying to produce a Black periodical called The Sentinel. I've not been able to find The Sentinel, but it's in 1887 that he shows up on the scene. Judge Brenda Hubbard Forte has brought to light the story of Annie Virginia Stevens Coker, the first Black woman lawyer in the state. We're going to hear more about her later on, but she graduated from Berkeley Law in 1929. For a long time, I thought Lawrence Sledge, a Charles Houston Law Club founder, was the first Black lawyer in Oakland. Now, this is significant to me because I live and work in Oakland. Lawrence Sledge used to call himself Lawyer Sledge all the time. That's how he referred to himself in the third person. He was a church deacon. He had a career as a lawyer starting in 1897 in the state of Oregon, where he did all sorts of stuff, some of which I'm going to tell you in just a moment. But he came to California in 1908 to start practicing. And in 1910, he was the only Black lawyer practicing in Alameda County. Now, I had occasion in some of my history investigation to track down some of his descendants. And I'm grateful that they wanted to share some of what they have about him. So here's one of the articles. This is an article from Seattle, where Mr. Sledge used to work. The restaurateur denied him any service on account of his color. And Sledge explained to him who he was and threatened to sue him. And thereafter ate for the next 3 days at the restaurant, breakfast, lunch, and dinner, making that restaurateur back up completely. In the old days, we didn't have the computer system. When you became a lawyer, you get your bar number and you'd go in some big computer bank somewhere in the cloud. No, your name went in the book. So this is the role of those admitted to practice in the Supreme Court of the state of California. And there's Lawrence Sledge's signature, 1908, when he began practice. Now, Lawrence Sledge is a significant figure for this reason, principally. And so you're looking at the McDonough Theater, downtown Oakland. And back then, all the big shows came through there. And after D.W. Griffith's film, Birth of a Nation, started touring the country, it was going to play at the McDonough Theater. And as you might expect, if you have any idea what of the contents of this Birth of a Nation film, the Black community was outraged. And they brought a suit at the Alameda County Superior Court in nuisance to stop the film from being played. And the guy they went to run the case was Lawyer Sledge, and another San Francisco Black lawyer named Towson Grasty, excuse me. Now, the effort was unsuccessful, but it did galvanize the Black community once again around a common cause, bringing them together in strength. As my research continued, I found out Lawrence Sledge wasn't the first Black lawyer, because I found this guy, Washington J. Oglesby, who starts practicing in 1896, and they think he's pretty good by this article. Here's a couple more articles about the work that he's doing. And his name is spelled wrong in this particular article. And then this is the article of his death. Thomas Pearson is another Black lawyer from 1899 practicing in Oakland. He was born a slave and was originally from North Carolina. And this is reportedly the first colored lawyer to practice in this county. This would be Contra Costa County. His name is George Washington Young. And apparently in 1906, he won a case at the Justice Court in Point Richmond. State Bar California has issued publications, and they credit Oscar Hudson as being one of the first Black lawyers admitted to a private bar association. He was admitted in 1911, and this guy was really something else, a true Renaissance man. He was hired as a Spanish translator during the Spanish-American War in 1898. By 1919, he had been appointed foreign consul to Liberia at the Oakland port. He started his own newspaper called The New Age, which focused on Black interests. And this guy was the criminal defense lawyer who represented everybody if you were Black and in trouble, because he was the guy to go to. There simply weren't a lot of choices. A couple more images. This is the first Black judge in California, appointed in 1941. Can you grasp the fact that in 1941, during Jim Crow, a time when Blacks and whites can't even marry, that this man went to work each day and sat on the bench? Now, when he was appointed in 1941 to the Los Angeles Municipal Court, one of the bar leaders said, publicly, my grandfather would roll over in his grave if I had to appear in front of a Negro. But his career didn't stop. He was a very conservative man by accounts. He, I think his obituary said that he continued to use the word Negro long after it was out of contemporary usage. When folks were calling themselves Black, he kept calling them Negro, and that was something that rubbed some people the wrong way. But he had a very long, distinguished career, and as a first, we know his skin must have been thick, and he must have been extremely talented, and he, his perseverance is obvious. One of my favorite people to research has been Leonard Richardson, in part because he was the first Black man to graduate from Hastings, my alma mater, but also because he was a very successful attorney, probably the most successful monetarily Black lawyer in the East Bay. He had a good following of clients who in this Portuguese community. He also had some good clients in West Oakland. One of them was a guy named Raincoat Jones. Raincoat Jones owned some of the speakeasies. And I had the good fortune, in my journey of doing this history stuff, I've met a lot of wonderful people and just some very interesting folks. One of the people I had the good fortune to interview was a guy named Thomas Fleming, who's a journalist. And Tom Fleming told me that it was his job, because he was really good friends with Leonard Richardson, on Fridays to go on down to 7th Street in West Oakland and pick up a big, thick envelope full of cash from Raincoat Jones and run it by Leonard Richardson's office, also on 7th Street, where he would be instructed to take that down to City Hall to the chief of police. And on Fridays, that's what Tom Fleming would do faithfully. An interesting time. Charles Houston used to stay at Leonard Richardson's house when he would tour the country, touring the NAACP offices. And in fact, Len Richardson was one of those guys who was just what they used to call a race man. He fought a lot of battles for the NAACP for his entire life. He was a fixture on the board up here in Oakland, as well as down in Los Angeles, where he moved later on. In fact, his first case involved a theater seating. There's another case I read about where some women were trying to be able to use a public pool. They even offered to use it on the day before it was drained. The YWCA refused, and they called Leonard Richardson in to help mediate and get them the opportunity just to swim in the pool. William Patterson he graduated from Hastings, but he didn't end up practicing here. He didn't pass the bar in California. Instead, he moved to New York, where he had a long career, and he's known, among other things, for a document called We Charge Genocide. This is a study he presented to the General Assembly of the United States, accusing the United States government of torture and murder and other atrocities against Blacks under color of law. A very bold move. In his life, he worked on the Scottsboro boys case. He got his law books from Len Richardson when he started studying at Hastings. And he was once arrested at an Oakland park because he was arguing out loud that World War I was a white man's war, and there was no reason for him to fight it. They threw him in jail for that. And guess who represented him? Oscar Hudson, to get him out of custody. Tabitha Anderson is also interesting to me. She started at Hastings, completed her 1L year, but then transferred to Howard, where she studied under Dean Charles Hamilton Houston. She came back to San Francisco, her hometown, set up her own private practice, didn't really make a lot of money. You can just imagine what it was like to be a Black woman lawyer in those days. She was the first in San Francisco. And she ended up running for the presidency of the San Francisco NAACP, which was a coveted leadership position, and she prevailed. She was a real community woman. People looked to her for leadership, but sadly she died shortly after she was elected president of the NAACP. Now here's a quiz. Who do you think this guy is on the right? I'll wait. I'll give you a clue. He went to Hastings, and listen, don't think we're not Hastings centric because I went there. Hastings is a mill. A lot of people come out of Hastings, all right? This is Wiley Manuel. So guess how Wiley Manuel gets in the Attorney General's office? And he's the only one, you can see him circled there. Wiley was so smart, he was always at the top of his class at Hastings all 3 years. And he was also editor of the Hastings Journal. Now, as editor of the Hastings Law Journal, people write notes. And one author of an article or note for the journal was a lawyer in the Attorney General's office. And so one day Wiley and a classmate walk over there to talk to this attorney about his note. And so they go over to the Attorney General's office and they're talking, and in making some small talk, the attorney says to Wiley, "Hey, so how you doing in school over there at Hastings?" And Wiley, my mind has it without any evidence to say this, I just imagine him kind of kicking rocks and putting his head down and saying, "Oh, I do okay." Well, the story goes, his friend jumped in, interrupted the conversation and said, "What are you talking about, Wiley?" And explained to the attorney that how over the 3 years that Wiley had been at Hastings, he was consistently at the top of the class. And I mean, number one. I don't mean like in the top quartile. He was in the top 1 or 2. And he was Order of the Coif. I mean, he was all that. Now, upon learning that, of course, Wiley gets an invitation to join the Attorney General's office, and he was the first in that office. So he was the first African-American to join the office. He did such an incredible job. He just rose up through the ranks. It was just a matter of time after becoming chief that he would get his judgeship. We were lucky to get him over here at the Alameda County Superior Court, where he only sat for a brief period of time before he was appointed an associate justice to the California Supreme Court, becoming our first Black Supreme Court justice in the state. Jane Van Hook is one of our early women lawyers. She had a distinguished career. She's from the Hastings class of 1956. Her obituary claims that she's the first Black woman to graduate from Hastings. She was originally a native of Texas. And she's one of the first women who was active in the Charles Houston Law Club because she graduated right after the law club began. Lionel Wilson's the first Black judge in Oakland. He served also for 3 successive terms as the mayor of Oakland. He was the first Black judge here in this county. And at the urging of a white judge named Jim Agee, who suggested that he join us. I'm going to pass by this slide for just a moment to talk about Claude Allen. Claude Allen was admitted in 1954. He was born in Mississippi, and boy, he had seen it all. One day in his hometown, he saw a Black man dragged by a car. The Black man had been killed. That's the type of racism he experienced in his early life. He was in the service. Oh, but before that, another interesting thing about him is he was a baseball player for his high school, and he was the catcher. And one thing that he just cherished was a memory of one day Satchel Paige came to town, and he got to catch balls pitched by Satchel Paige. Now he clerked for attorney John Henderson when he, after making it to the Bay Area and deciding he wanted to be a lawyer, and he took John Bussey's bar review course in order to prepare for the bar. He was successful. He ended up moving into a white neighborhood in 1956, whereupon the community burned a cross on his lawn. This is Charles Wilson, the guy that Justice Clint White was talking about in that article. He's the guy who walked into court, and Judge Fitzpatrick said some things that offended everybody. Charles Wilson. Now, the article talks about him saying the ace of spades. You just heard Justice Clint White refer to something else. I don't know what's most accurate or whether both statements are accurate. What I do know from this article is that Judge Fitzpatrick in San Francisco acknowledged making this remark, the ace of spades remark, but said he intended no insult and therefore refused to apologize, as it had been demanded by both the NAACP and by these Black lawyers who are now getting together as the Law Club. Admitted in 1932 is this gentleman, John Henderson. He had his own practice over on 7th Street in West Oakland. He later moved it to 10th and Broadway. This guy planned to run for judge, but he died in 1952 under mysterious circumstances. He was his daughter told me that he was the only Black lawyer on a case in Vallejo involving multiple defendants that involved Black sailors. And at the end of the trial, only his Black client was acquitted. And then after that, the phone at his office rang off the hook. This is Tom Berkeley, an amazingly successful entrepreneur. He was admitted in 1942. And the day he passed the bar, word shot around the community. And a guy named George Vaughns came down, knocked on his door, and invited him to join his practice. You see, in those days, you couldn't get a job anywhere. The government wasn't hiring you. The firms weren't hiring you. You really had to hang out your own shingle. And what ended up happening was community was developed. And established Black lawyers, the few that there were, always extended themselves to new professionals who were just entering the practice to offer them a home to begin their new practices. And the same was true for Tom Berkeley. This is what he did for countless other people, as I'll get an opportunity to discuss very briefly in a moment. I want to talk about Carl Matoyer. He was the first Alameda County president of the Bar Association here, but he has some words for us to explain what it was like to be at the top of his class, because like Wiley, he was at the top of his class, but was completely unemployable afterwards. And I think looking at the time, I'm going to end with these profound words. The audio is messed up. I interviewed him a couple months, well, twice actually. Once when he made me pay for his lunch at the what's now the Black Bear Diner in Emeryville. It used to be something else. And then another time with Judge Colin Bowen, shortly before he passed. And this film was put together after that. Turn up your volume. I messed up the mix, but there are subtitles.
Commanding officer of our unit told me, Carl, you ought to take the examination to go into officer's training school. So I did that. Went to officer's training school, went to the exam, passed, got a grade. He told me, Carl, I hope you don't misunderstand this, but you should, if you offer an appointment to the Naval School, not the Naval College, training, officers training rate, you should decline it. It's because I think the war's going to be over before long. And if you sign it, you take that appointment, you're stuck with it for 2 years. And that 2 years can be well spent in prep yourself for law. What motivated me in that way is, at that time, whites weren't, like it is now, whites weren't taking black attorneys. Notwithstanding the fact that I graduated with or quite #1 in class, etc., I did not receive one offer of appointment as an attorney in an office, as an attorney in an office. In San Francisco had a lot of law, but not one. And it was fairly well publicized. The Asian black who led his class, Hazing, is not a second-rate college.
So I'll tell you, I could go on and on and on and tell you about how the firms started to develop, what they looked like, how they evolved. Again, here's my Torres firm right there. This is a listing from 1967, my birth year of the firms in the East Bay, headed by black folks. If I could talk about the first black judge in San Francisco, our second associate justice on the state Supreme Court, first black judge in Alameda County, Judith Ford, second black judge in San Francisco, Cecil Poole, who was U.S. Attorney, District Court Judge, Northern District, California, then appointed to the Ninth Circuit, and a ton of people doing amazing work every day, all of whom deserve so much recognition. I don't have that time. I hope that in listening to, watching these slides and listening to me talk, you have some understanding of where we are and how far we've come and how far we have to go. I see history as a great way to figure out where you belong in a long story, still evolving, where we have the opportunity to make significant contributions and continue that work. We all belong to justice institutions and a profession that has done great things and it has done not so great things. I've talked about some of those today. And we have an obligation to use the force of history for good and to make sure the institutions we're a part of do not replicate some of the harms that have been experienced in the past. So I thank you for your attention. I'm really excited to be on a panel with people I've always looked up to, and we're gonna move over to that portion of this presentation now.
Thank you so much, Judge Smalley, for that incredible presentation. So much very valuable information. And as I said at the beginning of our program, there's so much rich history that there's no way we can cover it all in 2 hours. We're definitely going to have a sequel, but we want to get into some other parts of our program. And Judge Smiley, I think you probably have answered this question, but I just wanted to give you a chance to respond. What inspired you to start putting together this very valuable Black legal history?
Well, a couple of reasons. I did answer. The initial idea was that the stories weren't being told. I knew that different people were out there collecting this information. Brenda Harbin Forte and Robert Harris are among two of the people I solicited information from early on in the process. It's also fun. I mean, and for me, it's a way to give context and purpose to my own career, to figure out, where on this arc towards justice I might belong, and to understand something about, where I'm coming along in history, and it helps me figure out what I feel I need to do, what my mission is. So I'll leave it at that. The fun part, though, is in investigating and being inspired, because when you investigate this history, you put yourself into the stories of great people who had to endure hardships that I know nothing about, but from whose work I benefit immensely. So that's how I'd answer that question, Terrence.
Thank you so much, Judge Smiley. And I just wanted to, before we get into our next question, to let folks know to feel free to use the Q&A feature if you have questions. I think I've responded to some, and we'll try to get to them in the course of the program. But this creates the perfect segue for Judge Brenda Harbin-Forte, and you were mentioned in Judge Smiley's presentation about the research that you did in discovering the first Black woman lawyer in California. And I wanted to give you the opportunity to talk a little bit more about that as we dig into some of the other great work you've done.
All right. Thank you, Terrence. Good evening, everyone. What I want to do is talk a little bit about Annie Virginia Stevens Coker, California's first African-American woman lawyer. Let me tell you how I got to Annie Virginia Stevens Coker. I was attending a program that was put on, it was called Then and Now, and it was put on by the Historical Society for the Northern District of California, the Federal Northern District Historical Society. They were doing a program on Then and Now, and they were talking about women pioneers in the law. And they talked about Clara Shortridge Fultz and others and everything. And I'm sitting there thinking throughout this program, okay, when are we going to get to something about Black women and Black lawyers? And they never did. And so not being shy, as I've said, not being shy, I talked with the presenters and I said, what about the first Black woman lawyer? Can we do something on her? And they said, fine, if you want to write an article, we'd happily publish it. This was 1987. And so I wrote an article. I found out who the first Black woman lawyer was. I talked with her friends. I talked with colleagues, people she worked with, and I got her life story. And I published my first article in 1987 in the Historical Society. That article is in your syllabus materials. And it talked about Annie, her life. As women do, she really, really loved shopping, but she was well respected in her community. I'm glad too I get a chance to talk about Bolt Hall and my alma mater. Annie was a double bear as I am. She went to Cal undergrad and she graduated in 1924. And then she went to Cal Berkeley's law school and graduated in 1929. There were only 2 women in her class, that 1929 class. So you're talking about basically the same year that the stock market crashes, we got our first Black woman attorney in California. In terms of what Annie did, she worked at the State Office of Legislative Counsel. And in your program, by the way, the syllabus materials that I've supplied, you'll see a picture of her in her law school graduation gown when she got her law degree. But she has been the inspiration for all of us and every Black woman attorney in California and elsewhere. Stand on her shoulders. Do you want me to go and talk about the other first and just keep on going, or do you want to?
Oh, sure. Yeah, so I wanted to, and thank you, I wanted to direct folks to the research you did that was published by the Daily Journal. And I'm actually going to share my screen if I may. This is an article that you wrote, and it was published March 26, 2019. And you talk about some of the important firsts that Black women have achieved in both the trial courts, the appellate courts, and the federal courts. And would you be able to talk about that, perhaps starting with the federal courts?
Sure. The first Black woman on the federal court in California was Consuelo Bland Marshall. She was appointed to the federal bench in 1980. She had wanted to be a lawyer. She told me her story. I got a chance to interview her when I first did the article in 1987, because it talked about the first Black woman lawyer, the first Black woman state court judge, and the first Black woman federal judge. So I talked with her and interviewed her and got her life story and what inspired her. But she is now a senior judge. But she was incredible, very well respected as well on the bench. She had been born. She was born in Knoxville, Tennessee, and earned her bachelor's degree at Howard University. And then she worked in the Los Angeles City Attorney's Office. She met and worked with Johnny Cochran and others. And she really was, she ascended all the rungs of the judicial ladder. She served as a court commissioner. She served as a municipal court judge. This is all in Los Angeles, and a superior court judge before she was appointed to the federal bench. And for many years, she was the only Black woman federal court judge in California. As we talk about the federal court, let me give you an update here, an astounding and very sad update that in the entire state of California today, there's not one active African-American female federal court judge, not anywhere in the state of California. We have some senior judges, and in fact, in the entire Ninth Circuit, there's not one active federal court judge. We do have a senior federal court judge who is in Nevada, and in California, we now have two senior federal court female judges on the bench. So we have got to do something about that. And we'll talk about that later on as I talk about judicial diversity. One of the reasons we want the voices of women heard is that we have our own unique experience, and we bring something to the table. I quote in the article in the Daily Journal what Justice Powell said about what Thurgood Marshall brought to the Supreme Court. And Powell said that Marshall told us things that we knew, but we would really rather forget. And Marshall also told us things that we could not know due to the limitations of our experience. And because women have a different experience in this society, that view needs to be shared. That view needs to be a part of the jurisprudence, a part of the information that is brought to bear on judicial decisions. But that was our first federal court judge, and since then we've had other federal court judges. And with respect to the federal courts, there the article mentions again, Ninth Circuit, no one in California or at all anywhere now in terms of women, in terms of active positions. In bankruptcy court was Eretha Smith, who was appointed in 1994. In the Northern District of California, the first Black woman judge there was Sandra Brown Armstrong, who was appointed in 1991. And in the Central District, as I mentioned, Consuelo Bland Marshall. And in the Eastern District and Southern District, there have been no Black women federal court judges appointed there. Thank goodness we have now an administration that I hope will listen to the need to appoint African-American women federal court judges in California. There are now 3 vacancies on the federal bench in Northern California. And we're hoping that our cry, our plea is heard, and I'm advocating for appointing at least 2 Black women to the federal bench here in California. We're long overdue.
And Judge Harbin-Forte, in your article, the Daily Journal article, you also talk about the impact that Black women have had on the California appellate courts. Can you speak a little bit about that?
Yes, as you can see, we have, there had been not a lot of Black women on the appellate courts. In the first district, we do have now, and when the article was published in 2019, we did not have a first Black woman appellate court justice. In the Bay Area here, first district is centered in San Francisco, one of the most diverse parts of our state, and the voice of Black women justices had never been heard on that first district. Thankfully, we now have an appellate court justice, the first Black woman appointed to the first district, Justice Terry Jackson, who is now on that court. Second district, the first Black woman justice was Arlie Woods in 1980. Third district was Justice Janice Rogers Brown. You see her picture there. And she was appointed in 1994. Fourth district was Carol Codrington in 2010. And there's never been a Black woman justice on the fifth district or the sixth district. So we still have our work to do on the appellate courts. Granted, not every case, of course, is going to get to the appellate court, but those decisions that are being rendered are, of course, binding on the trial courts. So why shouldn't our voices be heard? And why isn't our voice heard? It will continue to take advocacy so that Black women are represented at every level of the state court, as well as the federal court. And we can talk more about that when you wish.
Oh, sure. And Your Honor, you also mentioned in this article, and it's a perfect segue, about the impact that Black women have had on the trial courts of California. Can you speak a little bit about that?
Yes, our first state court judge was Vano Spencer. She was appointed in 1961. It was about 32 years or so after we got our first African-American woman lawyer. And Vano Spencer was actually in real estate. She was that was her first career, and she was working with another real estate person. And that person was taking the bar and studying. And Justice Spencer, she eventually got appointed to the Second District Court of Appeal. But she said, well, I figured, if he could go from real estate into law, that I could do the same thing. And so she studied for the bar and passed the bar and became a lawyer. And again, in 1961, she was appointed to the municipal court as the first Black woman judge on the state courts. She went on, again, as I mentioned, to be appointed to the Second District Court of Appeal, and went on to be very active in Bar Association events as well. And was a founding member of the National Association of Women Judges as well.
And Judge Robin Forte, as you look at where we are and where we've come from, and you kind of look to the future, what is the argument? And I know that President Biden has said that his first appointment to the U.S. Supreme Court will be a Black woman. What are your thoughts on the need to have Black women represented for the first time on the United States Supreme Court?
We are way overdue for a Supreme Court justice, a Black woman Supreme Court justice, way overdue. Again, the fact that our voice, it's been a truism that experience is a life of the law. And so the experiences that you bring to bear to your decision-making is what enhances that decision. That's what makes it more fair and more just. When you leave out an entire segment of our community, when you don't include that voice and that perspective, then you are not delivering the highest quality of justice. So we need that kind of a perspective. We need that difference. We know as well, and just in general, I didn't get a chance to go through all of the Black women on the bench, but it is in the article, the first Black women. But there are still only 19 counties, 18 counties that have a Black woman on the bench. So the voices in California and many counties, you are not getting the experience of Black women. So we still need to do a lot of work there. But yes, we are long overdue.
And
Kamala, Joe,
right.
We're long overdue.
And speaking of Kamala, I just want everybody who's part of this meeting to know that Kamala is an alum of the Charles Houston Bar Association. So yes. Our Bar Association produced the first Black woman and first South Asian woman vice president of the United States. And that is a perfect segue to to Bob Harris, you have been very instrumental in the civil rights movement and in the formation of the California Association of Black Lawyers, past president of that organization, past president of Charles Houston, past president of the National Bar Association. And I wanted to get your thoughts on cases that you've been involved in and Charles Houston has been involved in that dealt with civil rights. I know when you and I talked, you mentioned the NAACP and First Amendment, and I just wanted to give you a chance to talk about that history.
Yeah, well, thank you very much for this opportunity. First, let me say how impressed I am with the presentation by both Judge Smiley and Judge Harbin Forte, both of whom I admire and have sort of mentored them over the years. They've done just fantastic work. It is true that I did argue a case before the United States Supreme Court on First Amendment issues. It was out of those, it was out of my knowledge of the First Amendment that I was able to work with the Charles Houston Bar Association in one of its first cases where the Bar Association actually sued the Alameda County Bar Association and Alameda County because of the way that they were handling cases that related to indigent criminal defendants in cases where there was a conflict with the public defender's office. The first thing the Alameda County Bar Association did was, guess what? They based the rules upon seniority, recognizing that Black lawyers wouldn't qualify for the most serious cases, but only for the crimes. We sued them in the Alameda County Superior Court, first for a temporary restraining order, and then for a permanent restraining order. And while we did not win the suit, what we did was negotiated at a settlement where the Alameda County Bar Association got rid of all of those rules that we had complained about. So that was a real victory for the Charles Houston Bar Association as a plaintiff. The second case involved the San Francisco Police Department and the Oakland Police Department suing the NAACP every time the NAACP would complain about police brutality, knowing that the NAACP didn't have the funds to represent itself. So what Charles Houston Bar Association lawyers did, we decided that we would defend both cases, San Francisco and in Oakland, pro bono for no fee, not even filing fees. We took on the responsibility for those cases. We won the motion to dismiss in San Francisco Superior Court. We won a similar motion to dismiss in Alameda County Superior Court on the grounds that those defamation lawsuits that were filed were designed to intimidate Charles Houston Bar, to intimidate the NAACP, and therefore was a violation of the First Amendment. And we were sustained on both cases. It went all the way to the Court of Appeals, and the Court of Appeals affirmed the lower court's decision. So those are just two examples of some early cases where Charles Houston Bar Association was actively involved in litigating on behalf of the NAACP and others.
And Bob, you also mentioned that the Charles Houston Bar Association was involved in the founding of the California Association of Black Lawyers. And I think that's an important piece of history that folks don't know. Can you shed some light on that?
Absolutely. The Charles Houston Bar Association was played a key role. As a matter of fact, Charles Houston Bar and Langston Bar, but Charles Houston Bar Association was the one that really led that effort in 1977. Ben Travis, the visionary Ben Travis, who had by that time become a Superior Court judge, but had laid the foundation for transitioning the law club into a bar association. Ben didn't stop there. His vision was that we need, and those of you who know BT will recall, he was always telling my little brother, little sister, we need to form an association of Black lawyers. And sure enough, we were able to form an association of Black lawyers in California. In 1977, I had the privilege, since I was president of Charles Houston at the time, of presiding at the first meeting of the association. And of course, I was never president of the association, but clearly was one of the founders and played a key role in terms of its early growth and development. And I cannot say enough. And for those of you who want to know more about it, you can read it in my book called Goodbye Arkadelphia, Turning Obstacles into Opportunities. Got that plug in. You can see the founding of the California Association of Black Lawyers and how that came about.
And for the folks who are watching, we're going to send an email to all the folks who registered that will have information and links to written materials and where you can get this information. I also wanted to ask you, and I know we're short on time, but I think it's important, if you can talk a little bit about the California Code of Civil Procedures, Section 527.7, California's anti-KKK legislation.
Yeah, and that's very important, because if you look at the statutes of California, you'll see, and do research on them, you'll see that's the first time in the history that a bar association, Black Bar Association, came together, Cable and Charles Houston, to deal with an issue where in 1980, a group of white men got bored hunting for deer and decided up in Chico, California, to shoot a Black man. And as a result of that, the whole issue of the Klan, and they were Klansmen, surfaced. And we went to Diane Watson, who was then the state senator, now later a congresswoman, and got her to sponsor some legislation, 527.7 of the Code of Civil Procedure. And as you read that, you can see it's very specific. We argued that the Klan or no other group had no right to advocate imminent danger against Black folks and or anybody else. So that was passed in the law, and very few people know that it was the Charles Houston Bar Association and Cable that sponsored that legislation and got it enacted into law. And it's been on the books since 1982.
And Bob, I also wanted to ask you about an interesting bit of Black Bar Association history, and that's when the California lawyers invaded the leadership ranks of the National Bar Association in 1976. Can you shed a little bit of light on that?
Yeah, now that was a real tough one there. Ben Travis, it was his idea that the Black lawyers ought to have a seat at the table with the National Bar Association. I wish I could take some credit for that, but Ben Travis was the one who laid the foundation for that. Ben Travis and a judge from Los Angeles, Judge Cunningham, they were hell-bent on getting someone elected as an officer in the National Bar Association. So we invaded Houston in 1976. And I was 3 years out of law school. And for some reason, they decided to push me to become the first officer of the National Bar as a vice president. And I was on their coattails elected. And no credit to me, but solely because of their reputations, I became ultimately 2 years later, the first president of the National Bar Association.
Wow. Thank you for sharing so much of that important history. And this is a perfect segue to our friend, the Honorable Judge Demetrius Shelton. Demetrius, you have really paved the way for so many people, and you followed in the footsteps of so many great people. President of Charles Houston, President of the California Association of Black Lawyers, President of the National Bar Association. If I went through all the many accomplishments, we would be here all night. But I want you, if you could just, for the audience, if you could explain the significance that these important institutions have had as it relates to civil rights and their significance even today.
First of all, thank you, Terrence, for inviting me to be a part of this esteemed panel as we celebrate Black history, our history this evening. It is extremely important that we celebrate our history, not only to pay homage to those well-deserving individuals who paved the way, but so as to inspire us to do better, to be great today. To follow in the footsteps of those who we pay tribute to, be staunch advocates in promoting justice and equality and paving the way for those who come after us. I'm a firm believer that we should use the past as a teacher for confronting the present and inspiring us to address the current problems that we face. In recent years, there appears to be an all-out assault on our rights and freedoms, and we, unlike any other profession, are equipped to address these ills. As to activism and Bar Association and Black attorneys, as skilled legal practitioners and advocates, we must utilize our skills as have our ancestors to beat back any and all efforts to abridge our civil rights. We led the way before, demanding equality and justice under the law. Through our election protection efforts and safeguarding the vote, which gave rise to America's first Black president, attorney Barack Obama, who brought with him First Lady attorney Michelle Obama. And we also played a significant role in safeguarding our census protections, which was a hot issue this year. And in many instances, we continue doing so as our nationwide legal community fights for justice in police and criminal justice reform. On countless occasions, we have stepped out in front on an issue, later to be joined with much appreciation in our quest by others, but only after we have taken the hits and gained traction to be joined by others with similar goals. I say this to emphasize that we must be intentional in telling and preserving our history. Our legal community is broad, and recognition of our efforts should encompass all facets of the community, locally and nationally. We must recognize our present bar leaders, such as NBA National Bar Association past President Benjamin Crump, as we watch him become a living legend in advocating for justice and civil rights. I must also mention National Bar Association Vice President Lanita Baker, attorney for the Breonna Taylor family, who is asking the world to remember her name and to say her name as she fights for police and criminal justice reform. So we must say her name, Breonna Taylor. Along with others worthy of mentioning as we chronicle significant contributions of attorneys within our legal community whose cases may not have arisen out of California, but have ramifications of national import and which affect us all. Chris Stewart of Florida, representing the family of Walter Scott, shot while running away and captured on a cell phone, and the incident captured on a cell phone video. And most recently of George Floyd, of which the world ached when he died at the hands and knees of police officers as he cried for his mother. We also have Lee Merrick representing Ahmaud Arbery, who was killed by vigilantes while jogging in a neighborhood in Georgia. And of course, we must mention Eric Garner, the case that gave rise to the chilling phrase in the movement against the use of deadly force by police in communities of color, and for the appreciation of Black lives. I can't breathe. Let us not also forget members of our bar, the California bar, while not practicing per se, use their legal skills in other significant ways. As mentioned at the top of my list, Attorney United States President Kamala, United States Vice President Kamala Harris, homegrown, as they would say, from Berkeley, California, and who started her career at the Alameda County District Attorney's Office, and now rising to represent us at the White House. And members of the California legislature, Willie L. Brown Jr. and Elihu Harris, also mayors of San Francisco and Oakland, respectively. And a fun fact for some of you who may not know this, Elihu Harris also previously served as executive director of the National Bar Association. And we have Judicial Appointments Secretary and now Justice of the California Supreme Court, the Honorable Martin Jenkins, and a non-judicial appointment secretary, Timothy Simons. And finally, leading community organizations such as the NAACP, having served as presidents in their region of the California Association of Black Lawyers. Earl B. Gillum, past president, LaCharla Wilson of San Diego, and Charles Houston Bar Association President George Holland of Oakland, and serving as president of the Oakland NAACP. In short, we must be aware. We need to be involved in the local bar associations, the national bar, the state bar. We need to be everywhere and working collaboratively.
Thank you so much. So much important history and so many important people. As I said, we could have this program go on for a long time because there's just so many people you want to talk to and talk about. I did want to give you an opportunity to talk about an interesting piece of Black history involving you and Judge Harbin Forte, how you worked together when you were one of the first Black leaders of the State Bar Association of California, and Judge Harbin Forte was leading the judges in this state to force the State Bar of California to track diversity. And I just wanted to give you both an opportunity to comment on that. Demetrius, we'll start with you and then Judge Harbin Forte.
Okay, one of the issues that we all will agree is that diversity in the courts is of great importance. And the California Association of Black Lawyers, of which I happened to be president at the time, mounted an effort in the 2005-2006 bar year, where then Governor Arnold Schwarzenegger had been in office for 2 years and had not appointed a single African American to the bench. We, the members of CABLE, led a campaign to change this. We called on the governor to appoint African Americans to the bench. We wrote letters, demanded meetings with key officials, and took our call to action to the media, which was covered by major news sources, including the Recorder and the Daily Journal. And it was only then that that administration started appointing African Americans to the bench. It is advocacy such as this, taking notice of where we are when we are receiving the short end of the stick, not being treated equally, and are left out of the equation, that we must mobilize and again take steps to address the situation in a meaningful way. Which brings me to your question. I serve as president of the state of California.
Oh no, it looks like we lost Demetrius' connection. Hopefully he can call back in, but Judge Harbin Forte, I want to give you the opportunity to respond. And if you'd like, I can share those slides while you talk about how you were involved. You're on mute. We can't hear you.
Okay, yes, hi. You can put that first slide up. I see that Demetrius is back though. But you can put, I'm sorry, the second, the bar graph. We can put that bar graph up. Okay. And yes, in 2005, the state bar started a pipeline diversity task force. And I was invited to be on that task force and invited to chair a committee that would look at judicial diversity. And in connection with that, we were very concerned about the lack of diverse appointments to the bench. In fairness to Governor Schwarzenegger, I think by the time we began, he had appointed a couple of African Americans to the bench, but not very many out of his total appointments. We decided that we needed to have a summit on judicial diversity. We started planning that summit in March of 2006. And I have to give credit to Judge Doris Cordell, who was the first African-American state court judge in Northern California. She was appointed in Santa Clara. We talked about when we should hold this summit, and we were talking about maybe in the fall or next year or whatever. And Judge Cordell said, "What are you talking about? This is an emergency. We need more Black judges on the bench. So let's do it as soon as we can." And we put together this summit, the first ever summit in the state of California, which I chaired and was instrumental in having, along with the committee, of course. And one of the things we found out was that we had no way of knowing how many judges of color were on the California bench. We could not go to our administrative office of the courts to get that information. We were unable to find that out. There was nothing that required it. Attorney Frederica McGee, a Black woman attorney in Sacramento, who was general counsel to Assembly Speaker Fabian Nunez. She had been advocating for judicial diversity as well, and had been going around the state. So we worked with Frederica. The first summit was held in June of 2006. Again, it was the first in the state. We brought together all of the stakeholders, including the governor's judicial appointment secretary, who was John Davies at the time. We brought representatives from the legislature, various chiefs of staff, including Frederica McGee. We brought all of the stakeholders together. The Chief Justice gave remarks, and we talked about the issue of diversity. One of the things that came out of that summit, or a number of things that came out of that summit, and thank goodness as well, that Demetrius had a leadership position in the state bar. Judy Johnson, now a judge, one of the Black women judges in California, was executive director of the state bar. So we were able to put things in place so that the state bar basically had no choice but to confront the issue of lack of diversity in our courts. When we put up slides that showed the population compared to the level of diversity on courts around the states, the room was quiet. I mean, it was just outrageous, the discrepancy. Even though California was even then a minority state, white judges on the bench just grossly exceeded the number of women, of judges of color in these communities. Out of that summit, legislation was passed that required the Judicial Council to collect demographic data on all judges and to publish that data every year so that we were able to track. But we did hand counting for that 2006 summit. And also the state bar, we needed to know who was getting through the state bar's Jenny Commission, the Commission on Judicial Nominees Evaluation that vets all judicial appointments, gubernatorial judicial appointments. What is faring there? A lot of Blacks in particular and other attorneys of color could not get through the Jenny Commission and be in a position to be appointed by the governor's office. We had the governor's office that legislation required. It's called SB 56. It required the governor's office to tell everybody how many Blacks are you appointing, how many Asian Pacific Islanders, how many Latinos are you appointing, and those reports come out. They're due by March 1st of every year. And so we've been focusing on that. I chaired the state bars. I was the first chair of the State Bars Council on Access and Fairness. It was formed as a result of that conference, and we track judicial diversity. We've had summits every 5 years, but I know we're getting close to the end, so I just wanted to run through a couple of stats. This is a bar graph that showed where we were. The first one where we were in April 1977 when cable was formed, and when the Judicial Council of Cable was formed as well. B.T. Ben Travis was the first chair of the Cable Judicial Council. It was called Judicial Section then, and I'm a past chair of the Judicial Council of Cable as well. But this is what our numbers look like. And in 1977, we had 51 women. And, I'm sorry, 51 total, and we had 47 men and only 4 Black women. These were justices, judges, magistrate judges, and commissioners. You go over to where we are, February 2021, the most recent stats, and these are sitting judges, justices, judges, etc. There are 193 total African Americans with 87 men. And look at what women have done in terms of where we are, 106 women on the bench. By the way, when women came on the bench, approaches to the law and legal issues changed. There was a different approach to domestic violence. There was a different approach to sex crimes. There was a different approach to gender discrimination and gender harassment. All of that was brought about because more women came on the bench, and more women demanded that there be different approaches to these kinds of issues that affected women and children and families. The next slide just shows ethnic diversity as of December 31, 2019. I think these slides are all going to be provided to you. That next slide sort of is a circle. You see who has the biggest piece of the circle. Think of it as a pie chart. Caucasians are less than 50% of the population, but they still command a huge percentage of our bench. And you'll see the breakdown of others. With respect to gender diversity, and we use 2006 as a starting point because that was the first year we held our summit. We've held judicial summits every 5 years. We did another one in 2011, another one in 2016, and another one that will be appointed. Will be coming up. And in your syllabus materials as well, you will get a report from the 2016 summit, which goes through the history of the various summits and the progress that's been made. Other diversity, now these various agencies, the governor's office, the administrative office of the courts or the judicial council now, and Ginny Commission are also required to report LGBTQ status, as well as veteran status, as well as disability. And those were brought about, again, by amendment, by new laws and statutes. So that is basically where we've come on judicial diversity. It has taken a lot of advocacy. I will say that we made a lot of enemies along the way. We were at the table, and those of us who were courageous enough to say, basically, we're not going to let you forget who we are and what we bring and what we have, and that we're entitled to be here and to have our voices heard. And we are entitled to have a bench that looks like California, which has a majority of citizens of color.
Judge Brenda, there was a question in the chat specifically about federal magistrates of color. Do you have that breakdown?
Yes, there are 2 magistrate judges 2 Black magistrate judges in California. One is Magistrate Judge Candace Westmore, who is here in San Francisco. The other is Magistrate Judge Stevens, who is in the Central District, I believe. But there are only 2 currently now.
Judge Harbin-Forte, I just wanted to thank you on behalf of everybody. The only reason I want folks to understand this, that we even know what the stats are because of the incredible work of Judge Harbin-Forte. Since we've run out of time, I just want to give folks a chance to make some final thoughts about why this history is important and what we need to do going forward. Hopefully we can have another program where we can get into some more of this information, and we're going to provide written materials to people who attended so you can have this. But we'll start with you, Judge Smiley, if you can just give some final thoughts on why this is important and what we need to do going forward.
Well, I think it's always important to have role models to help you refine what you want to do with this impactful profession. I mean, you can do so much with it as an attorney, as a judge, as just a legal professional, just anywhere that touches the system. The work we do is super important. When I think of history, I really think of the people who I try to emulate. Gordon Baranko, Felton Henderson, Martin, not Martin Luther King, Martin Jenkins. You know, I could go on and on about the people who inspire me to do this work and who, you know, I just want to bring just a fraction of what they've given me. Researching history just gives me a depth of appreciation for the work that I do. I hope it makes me better at what I do and the responsibility I try to discharge.
And Bob Harris, if you could give us your final thoughts about why this is important and where we need to go as we move forward.
It is important because so many people have worked so hard to lay the groundwork for what we do and why we do what we do. Tom Broom, George Holland, Horace Wheatley, Gordon Baranko, John Burris, Elihu Harris, Willie Brown, Hiawatha T. Roberts, Clint White, and on, all have made a collective decision that they would not be parasites on society. And we know what Charles Houston said about that. A lawyer is either a social engineer or a parasite on society. And that's what all of us are trying to avoid, being parasites. So we do the good work and we push for our Black Bar Association, because if we don't have Black Bar Associations, there will be nobody to fight the case for us.
Thank you so much. And Demetrius, if you could share with us your final thoughts about why this is all important and where we need to go from here.
Well, as been stated previously, our role in safeguarding our civil rights is of vital importance. We can't expect anyone to protect our rights if we don't do so ourselves. The takeaway I would want everybody to leave with is that we must stay active. We must stay on top of the issues. We must work together, and we need to be everywhere so as to be able to effectively address whatever issues of the day come our way. We've done it before. We can do it again. We just have to stay united.
And Judge Harbin Forte, did you have any additional thoughts that you wanted to leave us with as we move forward?
Thank you. I want to talk about some of the women pioneers. They've talked about men and everything, but let's talk about those courageous women who were often out there by themselves. Judge Judy Ford, when she was on the first Black woman in Alameda County on the bench there. Judge Elizabeth Riggs was the first Black woman in San Diego, and she took all kinds of abuse and disrespect. We still have judges around, Judge Doris Cordell, and in Santa Clara, who was not going to be quiet. She was not going to go quietly. You were not going to disrespect her. And so there are tons and tons of women, lawyers and judges around the state who have said, we will not be silenced. And that has to be our mantra. We cannot be silenced. We have to speak up. We have to speak out. And we have to demand change. Nobody is going to do it but us. So if we get a seat at the table, I'm going to encourage everybody, make a difference when you're there at that table. Make a difference. Raise the issues. It will make people uncomfortable, but that is your job, to raise those issues, to demand change, and to fight for that change. And you'd be amazed at how many things can come about, how many positive things can come about when we raise our issues. I'm going to end with just one little story, one anecdote about Judge Elizabeth Riggs in San Diego. When she took her check to the bank, her judge check to the bank one day, and she said that the teller looked at the check, and I think even showed it maybe to somebody else. And she's like, wow, wow. She said, that's the biggest welfare check I've ever seen. Just assuming that this Black woman judge was on welfare and was getting some kind of check. So those are the things that we fight for. But women make a difference. I can't name all of the women judges. They're in my article. there, those first, and again, we still have Donna Frencher Reeves is down in Santa Clara in Stanislaus County. She was the first and is the only woman, Black woman on the bench. Marla Osborne Anderson was the first Black woman in Monterey County, still the only Black woman in Monterey County. She's been on the bench for over 20 years. There are others, Monique Langhorne in Napa. Tons of women who, and the problem is we are still making history. There are still a number of firsts that Black women still need to achieve. And I hope that in my lifetime, we are not talking about firsts anymore.
And speaking of Black women making history, we certainly can't wrap this up without giving our president, Nichelle Holmes of the Charles Houston Bar Association, an opportunity to give us some final words. Nichelle, what are your thoughts about where we need to go from here?
I think this is a great way to start. I think learning for us younger lawyers, learning about our history, continuing to fight. We find ourselves in very familiar times with where we are with social justice. So I am echo Mr. Harris's words about the need for Black bar associations. As many of you know, like I'm very passionate about giving back and doing the work. And so I just am thankful for all of you who have been my mentors, who we stand on your shoulders and we, emulate you and we follow you. And so we appreciate you sharing the history with us so that we can continue to fight. And so we just encourage everybody to get involved in any way you can, not just with Charles Houston. There are many affinity bars out there, and we just need to come together and continue to fight, because nobody else is going to fight for us. So I just appreciate everything that was said tonight.
And I just want to go ahead.
And Terrence, I just wanted to clarify. First of all, I apologize. I was disconnected for a moment, but I'm sure Judge Brenda Hartman Forte covered the story adequately, because she was there and she brought the substance to the program. But I'm not the first Black person to serve on the State Bar Board, as there were many others who served before me. But I was the first African-American elected to the board to represent District 3, which was Alameda County, Contra Costa, San Mateo, and Santa Clara. And sadly, that was in 2005, in the 21st century, that I became the first. But I just want history to be reflected accurately.
No, thank you so much for that. And I just want to take time to thank our speakers, thank the attendees, thank the sponsors for making this possible. I wish we could go on for a few more hours and get some more history, but we'll definitely have another program in the future. Thank you, and everybody keep supporting Black history. It's not just once a month, it's every day of the year is Black history. So thank you so much. And the speakers, before you log off, I want to get one more picture of all of you smiling, because that picture I took at the beginning didn't come out. So on the count of 3, we're going to 1, 2, 3. Thank you so much, everybody. Have a good evening.
Terrence, thank you so much for a wonderful program. Thank you. Thank you.
Oh, thank you so much.